Now, now we go into the penalty phase for Garcia because Banawa is not in it anymore. Well, she's back in jail, but this is just the penalty phase for Garcia. So I'm going to go ahead and start sharing that, and we can enjoy together.
Ready to be seated, please. Good morning, folks. Thanks for being back here this morning. At this point in time, now I'm going to instruct you on the law. Again, you'll be allowed to keep these your instructions. You don't need to make any notes unless we find a typo or some mistake that we need to fix. Again, what I would ask is that you read along with me as I go through them so that I can be certain that everyone's been through there in their entirety on at least one occasion. Members of the jury, you have heard all the evidence. It's now your duty to make a decision as to the appropriate sentence that should be imposed upon the defendant for the crime of first-degree murder. There are two possible punishments: life imprisonment without the possibility of parole or death. In making your decision, you must first unanimously determine whether the aggravating factors alleged by the state have been proven beyond a reasonable doubt. An aggravating factor is a circumstance that increases the gravity of a crime or the harm to a victim. No facts other than proven aggravating factors may be considered in support of a death sentence. The aggravating factors alleged by the state are: the capital felony was committed for pecuniary gain, and 2, the capital felony was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Cold means the murder was a product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, in order for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. A pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the degree of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. You have heard evidence about the impact of this murder on the family, friends, and community of Daniel Markell. This evidence was presented to show the victim's uniqueness as an individual and the resultant loss by Daniel Markell's death. However, you may not consider this evidence as an aggravating factor. As explained before the presentation of the evidence, the state has the burden to prove an aggravating factor beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating factor if you have an abiding conviction that it exists. On the other hand, if after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating factor exists, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the aggravating factor has not been proved beyond a reasonable doubt, and you must not consider it in providing a verdict. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, a conflict in the evidence, or the lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find that aggravating factor does exist. A finding that an aggravated factor exists must be unanimous. That is, all of you must agree that each presented aggravating factor exists. You will be provided a form to make this finding as to each alleged aggravating factor, and you should indicate whether or not you find each aggravating factor has been proven beyond a reasonable doubt. If you do not unanimously find that at least one aggravating factor was proven by the state beyond a reasonable doubt, then the defendant is not eligible for the death penalty, and your verdict must be for a sentence of life imprisonment without the possibility for parole. At such point, your deliberations are complete. If, however, you unanimously find that one or more aggravating factors have been proven beyond a reasonable doubt, then the defendant is eligible for the death penalty, and you must make additional findings to determine whether the appropriate sentence to be imposed is life imprisonment without the possibility of parole or death. If you do unanimously find the existence of at least one aggravating factor, and that the aggravating factor is sufficient to impose a sentence of death, the next step in the process is for you to determine whether any mitigating circumstances exist. A mitigating circumstance is anything that supports a sentence of life imprisonment without the possibility of parole, and can be anything which might indicate that the death penalty is not appropriate. It is not limited to the facts surrounding the crime. A mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that may reasonably indicate that the death penalty is not an appropriate sentence in this case. It is the defendant's burden to prove that one or more mitigating circumstances exist. Mitigating circumstances do not need to be proven beyond a reasonable doubt. Instead, the defendant need only establish a mitigating circumstance by the greater weight of the evidence, which means evidence that more likely than not tends to establish the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you must consider it established and give that evidence such weight as you determine it should receive in reaching your verdict about the appropriate sentence to be imposed. Any juror persuaded as to the existence of a mitigating circumstance must consider it in this case. Among the mitigating circumstances you may consider are: 1, the first-degree murder was committed while Sigfredo Garcia was under the influence of extreme mental or emotional disturbance. 2, Sigfredo Garcia was an accomplice in the first-degree murder committed by another person, and his participation was relatively minor. 3, Sigfredo Garcia acted under extreme duress or under the substantial domination of another person. 4, the existence of any other factors in Sigfredo Garcia's character, background, or life, or the circumstance of the offense that would mitigate against the imposition of the death penalty. Your decision regarding the appropriate sentence should be based upon proven aggravating factors and established mitigating circumstances that have been presented to you during these proceedings. The next step in the process is for each of you to determine whether the aggravating factor or factors that you have unanimously found to exist outweigh the mitigating circumstance that you have individually found to exist. The process of weighing aggravating factors and mitigating circumstances is not a mechanical or mathematical process. In other words, you should not merely total the number of aggravating factors and compare that number to the total number of mitigating circumstances. The law contemplates that different factors or circumstances may be given different weight or value by different jurors. Therefore, in your decision-making process, each individual juror must decide what weight is to be given to a particular factor or circumstance. Regardless of the result of each juror's individual weighing process, even if you find that the sufficient aggravators outweigh the mitigators, the law neither compels nor requires you to determine that the defendant should be sentenced to death. Once each juror has weighed the proven factors, he or she must determine the appropriate punishment for the defendant. The jury's decision regarding the appropriate sentence must be unanimous if death is to be imposed. To repeat what I've said, if your verdict is that the defendant should be sentenced to death, your finding that each aggravating factor exists must be unanimous. Your finding that the aggravating factors are sufficient to impose death must be unanimous. And your finding that the aggravating factors found to exist outweigh the established mitigating circumstances must be unanimous. And your decision, if to impose the sentence of death, must be unanimous. You will be provided a form to reflect your findings and decision regarding the appropriate sentence. If your vote on the appropriate sentence is less than unanimous, the defendant will be sentenced to life in prison without the possibility of parole. The fact that the jury can make its decision on a single ballot should not influence you to act hastily or without due regard to the gravity of these proceedings. Before you vote, you should carefully consider and weigh the evidence, realizing that a human life is at stake, and bring your best judgment to bear in reaching your verdict. Please also rely on the instructions I gave you previously in the first phase of this proceeding trial. And if you need copies of that, just let us know. We will get you a copy of that. Let's give them the verdict form. Everybody have a verdict form? Let's look at it. It is a little confusing. We'll make sure you understand. So step one, we the jury find as follows as the aggravating factor. Remember, the state is alleged two aggravating factors. Either the capital felony was committed for pecuniary gain, or the capital felony was cold calculated, premeditated. You would check whether you unanimously find that the state proved beyond a reasonable doubt this aggravating factor. As to each of the aggravating factors, you would make that determination. If you find that the state has proven no aggravating factors, in other words, have proven neither of the two, then your job is completed. Your foreperson should date and sign the verdict form, and you do not need to move forward. If you find that at least one aggravating factor has been proven beyond a reasonable doubt, then you would go to step two. There you say, we the jury find as follows: as to the sufficiency of the aggravators, the state proves beyond a reasonable doubt that the aggravating factors are sufficient to warrant the sentence of death, or the state did not prove that. Again, you would check your option there, that's unanimously proven by the jury. If you find the state did not prove that the aggravating factors are sufficient, you would date, sign the verdict form. Your job would be completed at that point in time. You don't need to go forward. If you find that the aggravating factors are sufficient, then you would go to step three, similar determination. You decide what you, in weighing the aggravating factors and mitigating circumstances, the state proved beyond a reasonable doubt that the aggravating factors outweigh the mitigating circumstances, or the state did not prove that. You would check that option. If you determine they did unanimously, then you would go to step four. If you find they did not, you would date and sign the verdict form. your job would be completed. And then step 4, we, the jury, unanimously find the state proved beyond a reasonable doubt that the appropriate sentence is death, or one or more jurors find the appropriate sentence is life imprisonment without the possibility of parole. Obviously, the first option has to be unanimous. The second option does not have to be unanimous, but you would check whichever you have determined be dated and signed by the foreperson. I know that's a little bit confusing, but it's a 4-step process. The state has to prevail on each of the steps for you to move to the next step. At this point in time, the attorneys will be allowed to make their concluding remarks. The state will go first, the defendant will follow. There is no rebuttal argument, so there are just 2 arguments. We'll start with the state of Florida.
May it please the court, counsel. Members of the jury, good morning. You got a chance to learn a little bit about the unique life of Dan Markell and his unique contributions to our community through the victim impact statement of his mother. And you learned that he was a gifted legal scholar, a devoted father, and that he is desperately missed by his family, his students, his colleagues, and the legal community. His life was cut tragically short by the reckless and incredibly callous and cold actions of this defendant, Sigfredo Garcia. There is no evidence that this defendant's role in this crime was minor or that he was merely an accomplice, as all the evidence indicates that he is in fact the one that pulled the trigger. The shots in this case were fired at close range, as you can see there in State's Exhibit 8, close enough to deposit soot on the face and arm of Mr. Markell as he raised his arm to protect himself. The height of this bullet is consistent with the taller of the 2 men that we know were there at the scene. And the accuracy of that shot is consistent with a straight on shot, close range, as you know, as opposed to a gangster style shooting. In the bus video captured moments after the crime, we see clearly the passenger in the white shirt, the driver's in a dark shirt. Consistent with the physical evidence on the scene, meaning the taller shooter, the wounds, and the test getaway driver, and all the one in the passenger, Dan Markell. And cool reflect in June of 2000. Comfort rental car and rented this car and then Noah wasn't in the vehicle. She wasn't guns for the trip. To be experiencing major murder. In this case, at his home, they were patient enough Tallahassee. After the murder to get home. That's 1,500 miles and 6 weeks to reflect and formulate the plan to murder Dan Markel. 1,500 miles to think about what it takes, what it means to take a life. 1,500 miles and 46 days between the time that first car was rented and the time that this man put a bullet in Dan Markel's head to change his mind, to back out. But that was not the choice he made. This is an intelligent man, this defendant, capable of getting a GED and working in the field of aeronautics. Garcia wasn't experiencing a bout of PTSD when he shot a hole in this Prius. He wasn't suffering any extreme emotional disturbance when he fixed that vehicle. And he wasn't under the domination of Catherine Magbanua when he sat outside the Premier Gym and waited 1 hour for Mr. Markel to complete his workout, patiently waiting, stalking his victim. He was calm as they followed Markel to his residence. At 10:44 a.m., all he had to do was call it off. Head home. They're right there by the I-10 exchange. Tell Luis Rivera, get on I-10, we're going home. But that was not the choice that Sigfredo Garcia made. At 10:51 a.m., another chance to back out, another chance to reflect on what it was that he was about to do. To take a father away from 2 little boys. The irony of him asking you to show mercy because of his lack of a father should not be lost on you. That mitigating circumstance as presented by the defense to you should be given very little weight, as he made the choice to take this father away from his children. Why did Mr. Garcia execute this man he never met? Was he under extreme duress? Was somebody forcing him to do it? No, he did it for money. This was a murder for hire. Catherine Magbanua didn't have to force him to come to Tallahassee or do anything. He wasn't under her substantial domination. He wasn't even with her. She wasn't even here in Tallahassee when he did this crime. And when he went home, he didn't see her then either. They met and then he went and stayed at Shrimp's house. Duress. He got payment as or would have you believe. A crappy father. And he did it. Official personality. That his chose the lifestyle. This in any of this. Purely out of greed. that you might find. A decision as nation of
It's not an easy. And the reason why now, meditation, okay? And make that appear to be such a unique scenario in this case, but it's not. How do you think most murders happen? From money and premeditation. First-degree murders require premeditation. What sets this murder apart from others? That's the question you should ask. What requirement should I have? What standard should I set to sentence somebody to death? 4 victims, children, terrorists, mass shooting. Those, I implore, are situations where the death penalty is appropriate. By no means am I mitigating the loss of Mr. Markel. But the options aren't death and a walk. It's death or life without the possibility of parole, which means regardless of your choice, Mr. Garcia will never step outside a prison. He will never get to walk outside of a restricted facility. So believe me when I say this to you, life in prison is no walk in the park. Let's talk about the 4 steps. The first step is if you believe that these aggravators are applicable beyond a reasonable doubt. The same standard you guys made a determination of as to innocence or guilt. It's a high standard, okay? So let's just give the government, in this hypothetical, the benefit of the doubt, and let's say you find both, or one. You get to go to the next step. And the next step asks you, are these 2 aggravators or 1 aggravator enough to kill somebody? And if one of you doesn't believe that that's the case, then that's it. If one of you believes that life in prison is the appropriate charge, that's the charge. That's the punishment. And if you're one of these people that believe that this is a scenario that life in prison has to be the just result, stick by your guns. This is a scenario where if you believe that life is the right life, if a murder, well, you know, how is it different? To consider. was under the influence. Right? Something. And the government out of control because of his. Remember who we're talking about? This kid was arrested when he was 6 years old. And then when he became an was arrested, one got 8 years. Those two. If he was under Catherine McManus, this picture out and did we point the finger back? Smartest defense. From the beginning. Domination. I mean, she had complete. Ignore the fact ways those acts about his drug addiction. He's had these records in the Department of Juvenile Justice. I didn't know who I was back. In his late teens, being a good listen to what I'm asking for. Right out. That is appropriate here. And I dominion and control. Charlie Adelson, he was going to messages to prove the love of his life That's dominion and control. And all factor in and of itself. I know you found him guilty of a real shooter. You know, to choose someone's fate. Those 4 steps and you want to jump off, jump off. Sanction this case.
The case to the bailiff. When you during deliberation, when all jurors are present in this case in person or Twitter, email, electronic devices, that gives them to the bailiff. Rules apply until any other. During this trial, the exhibits will be sent into the jury room with you when you begin to deliberate. I cannot participate in your deliberations in any way. Please disregard anything I may have said or done that made you think I preferred one decision over another. If you need to communicate with me, send a note through the bailiff signed by the foreperson. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. In closing, let me remind you that it is important that you follow the law spelled out in these instructions. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we've lived by the Constitution and the law. No juror has the right to violate rules we all share. Let's go sidebar, please. All right. Mr. Barton, you need to remain here with us. Rest of you may step out, begin your deliberations. Will we send any rest? Appreciate you coming. But we're always working. Let me make anything about your jury service. you whether you wish or not to talk about it. That's up to you. We appreciate you being here with us. We'll let the bailiff get you out of the building and let you get on your way. Thank you for your service.
You're welcome.
Have a good day. Do you need this letter, Ms. Barton, from the clerk?
Probably not. I'll take it.
Okay, stand right here for me.
Can you retrieve this? You can't get that. Okay. All right, everybody be seated. Let's discuss a couple of things. And just a second, I'll let y'all, is the jury, is the evidence in the same separation it was at the end of deliberations? Do you feel like the lawyers need to go through it again?
No, I double checked everything, it's in one order.
You've separated out what was for identification only,
Yeah,
and you've separated out what was just put in this proceeding. So,
yes,
all right, when we break, if y'all want to give a quick scan of the evidence, you're welcome to do so. It sounds like she's got it separated out. Let's talk about a couple of things first, Court. If there is a life recommendation from the jury, will the defense be ready to proceed to sentencing since there's only one sentence I'd be allowed to impose?
Yes, sir.
All right. We'll need a score sheet available for that, so go ahead. Prepare that, Ms. Kappelman, so we won't be delayed on that. Mr. Evans said there was some victim impact information that you wanted me to consider. You'll give me that. I'll review that in the interim. Mr. Sangha, have you discussed with Mr. Garcia representation on appeal?
Judge, as we indicated early on in the case, he became indigent, and so unfortunately, and our office does not do appellate work. So we would ask, I don't know if he needs to be declared indigent again.
Well, that's why I brought it up. Why don't you get a PD affidavit from the clerk and fill that out? And of course, it's still your obligation to perfect the record and file the notice of appeal. But once you've done that, if we have the PD affidavit, you can file your motion to withdraw and allow the public defender to take over the appeal. Anything else from anybody?
Not for Mr. Garcia, Judge.
State, anything?
Judge, I've marked as State's Exhibit 200, a court exhibit which contains the PowerPoint which the state presented in closing for penalty phase.
Okay. For record purposes only, it's not to go to the jury. So why don't y'all scan the evidence for it sent to the jury? With that, we'll be in recess till we hear further from the jury. And Barbara, if you need one more thing to do, I will need bail credit. Okay. We're good.
here we go.
All rise, we're now back in session.
Cemetery, please.
passenger, I was coming up to right. I do understand if that's okay.
Okay.
Jury's in the courtroom?
Russ Meisel, is the jury arrived at a verdict?
Yes, sir.
We have handed the bailiff, please. State of Florida versus Secreto Garcia, we, the jury, find as follows: as to aggravating factor, the capital felony was committed for pecuniary gain. The jury has found the state proved beyond a reasonable doubt that this aggravating factor exists. We, the jury, find as follows: as the aggravating factor of the capital felony was a homicide and was committed in a cold, calculated, premeditated manner without pretense of moral or legal justification. Jury has found the state proved beyond a reasonable doubt that this aggravating factor exists. As to step two, we, the jury, find as follows: as sufficiency of the aggravators, the state proved beyond a reasonable doubt that the aggravating factors are sufficient to warrant a sentence of death. As to step three, we, the jury, find as follows: as the weight of aggravating factors and mitigating circumstances, the state did not prove beyond a reasonable doubt that the aggravating factors outweigh the mitigating circumstances. It's dated and signed by the foreperson. Having made that conclusion, there was no reason to go to step 4. Either side wish to have the jury polled?
No, sir.
No, Judge.
This will conclude your service with us. We do appreciate the time and the attention that you have given us. I know it's been a long and arduous experience for you. We very much appreciate the time and the attention that you've given us. You've been very cooperative, and we appreciate that. You've been a very reliable jury. I try to run things on time, and y'all have by and large cooperated very much with that, and I appreciate that. Once you start letting things get out of whack on that, you end up sitting in the jury room a long time, and I try to avoid that. Let me discuss a couple of things with you. It is quite possible that you will be contacted by someone to discuss your deliberations. You're free now to talk about it if you wish, but I want you to understand you also have an absolute right not to discuss your deliberations. You have every right to simply say you'd prefer not to talk about it. Again, that's up to you. I don't know what kind of person you might be contacted by, but you might be contacted by someone wishing to find fault with what you've done. As I've said, you have every right to simply say you prefer not to talk about it. You will be receiving a letter from the court with our thanks. It will include in that an opportunity to seek counseling that we have arranged. That's something for you to decide. It won't be long-term, but they will at least you get started with some free counseling that the court has arranged. Then from there, you can decide how you wish to proceed. Sometimes we don't think about the impact we have on jurors. I do try to consider that, and that's something that we have arranged. You're done now, so I did want to comment on one thing that you were not advised of, just in case it's something that you were curious about. I know you've been kind of cloistered from hearing about the case. In Ms. Agbanowa's situation, to let you know that the state was not seeking the death penalty as to her. I don't know whether that was something that maybe you were curious about, but pondered that maybe some of y'all might be wondering what that situation was. It was decided before trial that you were not to be told that, for various reasons. But I thought that might be something you would be interested in knowing. That matter will be reset, and that we have not picked a new trial date on that, but eventually we will have a new trial date, and that matter will proceed. So probably longer than y'all wanted to hear. I know y'all ready to get out of here. We do appreciate all the time and attention that you've given us. We'll let you step out. The court administration people will get you out of the building. Have a good day. Thank you. I'm gonna need about 25 minutes. We're gonna proceed on this sentencing. I haven't finished my reading, so I'll reconvene at 11 o'clock and give me a chance to finish reading on what's been provided to me. So we'll reconvene for sentencing at 11 o'clock.
I just want to say thank you to everybody that's watched with me. I really do appreciate it. It's not something I've ever done before, and I wanted to watch this trial, and I thought, why not watch it on YouTube?
All right.
So,
Court back in session.
anyway, we're back now.
Be seated, please, folks. Is there any reason not to proceed to sentencing at this time?
No, Judge.
No, sir.
Any technical objection to the score sheet?
No, Judge.
Defense wish to be heard.
No, Judge.
Does Mr. Garcia want to say anything?
No.
All right. State.
Judge, the state, obviously you can only do one sentence, but the state would request a 30-year consecutive sentence on the conspiracy charge. And we do not have any evidence to present other than the statements that Your Honor has already reviewed.
Sorry, I left my notepad on my desk. Excuse me.
Looks deep in thought there.
I have reviewed the victim impact letters. Thoughtful and touching comments. Sanganik, come forward with your client, please. The jury, having found you guilty of murder in the first degree and conspiracy to commit first-degree murder, I do adjudicate you guilty of each offense. On count one, I sentence you to life in prison. Give you credit on that sentence of 1,238 days, which dates back to May 25th, 2016, which I understand to be the date of arrest. On count two, I sentence you to 30 years, Department of Corrections, to run consecutively to count one. There's no jail credit as to count two, since it is a consecutive sentence. As to count three, based upon the jury verdict of not guilty, I adjudicate you not guilty of that offense. Order mandatory cost $420, $100 cost of prosecution. Reduce that amount to civil judgment. Mr. Garcia, you have 30 days to file a notice of appeal. If you can't afford a lawyer, one would be appointed to represent you. And I would assume, Mr. Sanganet, you will assist him in getting the appeal filed and the record perfected.
Yes, Judge. We did provide the clerk. I don't know if we provided it yet.
Yep.
We have provided with an updated financial affidavit.
Did you review the affidavit? We'll take that up because you need to perfect the record before you move to withdraw, but we'll review that at that point in time.
Yes,
Does that leave anything outstanding from anyone?
No, sir.
Anything further?
No, Judge.
All right. Good luck to you, sir. We'll be in recess.